Can a child participate in a custody dispute? Well, that's the question Shirin and I will be answering today. Actually, I'm going to make it simple. The answer is yes. So, Shirin Abdi and I are family law lawyers, and yes, a child can participate in a custody dispute in several ways, and we'll be sharing some of those ways with you. And yes, we no longer use the terminology custody in Ontario. We refer to it as decision-making responsibility or parenting time. So, Shireen, I would have you jump right in to, talk about some of the ways that a child could get involved in a parenting dispute in Ontario.
Absolutely. So one of the ways is known as a voice of the child report. So a voice of the child report is basically a representation of the child's wishes in a neutral, non-confrontational way. It's usually prepared by a social worker or lawyer or another trained professionals, and these are trained professionals that are able to discuss with the children what their views and preferences are. These reports are often used when the child is mature enough. So at least, I would say in our circumstance, at least 7 and up, to express their views and preferences, because of course they have to be able to really be able to express them. Now, a voice of the child report can be done both privately and within the court. So it's not a matter of just, you know, court needing to do it. You can obtain a private voice of the child report. And yeah, that's one of the ways.
Okay. So yeah, you mentioned court. So usually when the views and preferences of a child needs to be determined, and you're in the court process, the one of the very first ideas people think of is involving the office of the children's lawyer, and I know that the office of the children's lawyer are also able to prepare a voice of the child report. But what else can they do to assist a child to participate in these parenting issues?
So they can actually get the involvement of what's called an Office of the Children's Lawyer, an OCL. And an OCL may become involved to represent the child's best interest and child's interest as a whole. And they basically advocate for the child. Now, the judge can request their involvement through the court process. The parties can make that request to the court, but the judge ultimately will be the deciding factor of whether or not to make that request with OCL. OCL is not definitive, even if the court orders OCL involvement. The OCL has the option, the Office of the Children's Lawyer
Yeah, I
will.
think we could even say the court requests that the OCL gets involved. Yeah, because they can't
Yes,
order them to get
the
involved.
OCL
Yeah.
themselves will whether or not decide whether to accept the file and then assign either a clinician or a lawyer to represent the child directly. So in terms of like how that goes about, now an OCL is usually recommended in cases where there's allegations of abuse or significant issues regarding the child's welfare and safety. And in that scenario, like I said, if the OCL decides to act, they might appoint a clinician to conduct an assessment, and they would meet with the parents, meet with the child to conduct what the child's views and needs are, or have a lawyer represent them throughout the entirety of the process. And essentially, just as mom has a lawyer, dad has a lawyer, so will the child. So at each court appearance, their views and preferences are being reflected when it comes to the issue of parenting.
Absolutely. Now, sticking with sort of the theme of court, it is possible for a judge to interview a child and for a child to give evidence in court, but this very rarely happens, if at all. Judges try to stay away from, speaking to the child directly. It requires special training to be able to talk to a child in a way that doesn't, you don't want them to be scared. You don't want children thinking they're in trouble and things like that. So very rarely would a judge do that, even though it's a possibility. And I've never had a child actually testify in any of my parenting trials, and it's just something that is extremely rare to happen. So in our system here in Ontario, the judges would generally try to get the child's views and preferences in some other way. But there's other ways. So there's Section 30 assessments, right? Parenting assessments that a parent can do. So do you want to talk a bit about that, Shireen?
Yeah, so a Section 30 assessment can either be through the court by way of a court order that a professional conduct that evaluation by way of a Section 30 assessment, or that the parties can privately retain an individual who's qualified in this field, I'll add that, who's able to conduct these assessments. And these assessments are more comprehensive. So if you think about, not just interviewing the child on a one-off basis to get their views and preferences, it looks at a very holistic, I wouldn't say holistic, but all-encompassing aspect. So they would meet with the parents, maybe observe parenting time. They would meet with their doctors, the children's doctors, or any professionals, including the school, their daycare, third parties as needed to basically make that assessment. And they'll talk to the professionals working with the child. They'll talk to, extended family if they need to. They'll talk to extended caregivers if needed, and they will make recommendations based off that assessment.
Absolutely. So whilst I guess we can say with the voice of the child report, it's just knowing what the child's trying to get to what the child's views and preferences are. It's essentially be a report of what the child wants or thinks they want. And the other is with the OCL, they can either prepare the voice of the child, they can either prepare I guess a report that's similar to what the Section 30 assessment would be, except it's done through the Office of the Children's Lawyer, or they can assign a lawyer that would be there, or you can get your Section 30 assessments privately through, professionals that are trained to do this. So anyway, I mean, does that pretty much, that sums it up right there, right?
That absolutely sums it up. And I think that they're all case specific as well, depending on the nature and the circumstances of the child, but also as it comes to the needs of the parties, right? So yes, most
Mhm.
of these things, if they're out of court and private, do need to be consented to. But the reality is that you're not going to be doing a voice of the child report for a child who's, 4 or 5 years old. Those are more
Mhm.
for children who are older, and it's more about the he said, she said about what parenting, about what the views of the child are with respect to parenting. And
Yeah.
like I think Angela's going to get to the point about what that really means in terms of what kind of factor basis that plays into.
Yeah, and I mean, simply put, I just would want to. It's just when, if we're looking big picture, when you're the idea when a court or even parties are trying to settle any kind of parenting dispute, the overlie the major principle all we're looking at essentially is what is in the child's best interest. That's really the big picture that we're looking at here. So there are little pieces, obviously the voice of the child's report, or the clinical assessment from the Office of the Children's Lawyer, the parenting assessment, all of these things are just to find what is in the child's best interest, what are their views and preferences, and it has to align with the child's best interest. And this is important because I find that a lot of times parents obsess over what the child wants. But you need to remember that the child's views and preferences are just one factor. And this is important for people who get scared and they're like, well, what if, the other side manipulates the child and the child says they want to live with the other parent, but it's better for the child to live with me because of XYZ. Well, remember that the child's views are only one factor in determining what is in the child's best interest. So if the child wants to live with one parent, but every other factor considered makes it, you know, not to be in that child's best interest, then of course the courts is not likely to lean in that direction. So remember that their views and preferences, it matters. The older they get, it matters a lot more. The views and preferences of a 12-year-old versus that of a 7-year-old would be completely different. Again, given the practicalities of getting an older child to do something they don't want to do. But for now, we just want you to remember that yes, the child's voice can be heard. It's not the end all be all. It's not just because the child said one thing that that's how it's going to play out. The courts would look at various factors to determine what's in that child's best interest. So, I mean, except you have something else to add there, Shireen, I think we could call it a wrap.
Nope, that's everything.
All right, guys, thanks for listening. Until next time, it's bye for now.
Bye.